Section 8 of the Real Estate Settlement Procedures Act of 1974, also known as RESPA, prohibits anyone from giving or accepting a fee, kickback, or anything of value in exchange for referrals of settlement service business involving a federally related mortgage loan. In addition, Section 8 of RESPA prohibits fee splitting and receiving unearned fees for services not actually performed. There is a two-part test for determining the legality of lender payments to mortgage brokers under RESPA. 1. Whether services were actually performed for the compensations paid, and whether the payments are reasonably related to the value of the goods or facilities that were actually furnished or services that were actually performed. This is why brokers can be fairly compensated for loans they have originated, but they cannot be given free trips or other things of value in exchange for referrals of business or in hopes of future business. For example, Best Lending has a promotion designed to encourage brokers to refer loan business to them. For each loan that is referred and closed, the broker obtains a point. 5 points qualifies for a trip to Hawaii. Best Lending also places printers, laptops, and tablets in the offices of various brokers to help upgrade their brokers' office equipment in exchange for an agreement by the brokers to refer a minimum number of loans to Best Lending during the year. Both of these examples are Section 8 violations. Best Lending may pay brokers for the work they perform associated to the loans they are sent, but they cannot pay a broker for having referred the loans. When the CFPB reviews possible violations of Section 8 of RESPA, it pays particular attention to marketing service agreements, or MSAs. MSAs often involve providers of settlement services in a mortgage loan transaction, such as the lender, real estate agent, broker, or title company. Any MSA that involves exchanging a thing of value for referrals of settlement service business involving a federally related mortgage loan likely violates Section 8 of RESPA. Although there are legal ways to have MSAs, they have been highly scrutinized by the CFPB over the last decade. Therefore, MSAs should be documented and be done within the confines of what is permissible. Let's discuss an example. A title company entered into unwritten agreement with individual loan officers, which it paid for referrals by covering the loan officers' marketing expenses. The title company supplied loan officers with invaluable lead information and marketing materials. In exchange, the loan officers sent referrals to the title company. This matter resulted in a CFPB enforcement action because the arrangement violated Section 8. Another example is where the loan officer pays a desk rental to sit in a realtor's office. Say the rental cost is above the market value for such a rental. In exchange for the above market rental cost, the realtor sends their clients to the loan officer. This is a violation of RESPA because the realtor is getting paid to refer their clients to the loan officer. RESPA imposes severe penalties for violating Section 8. The penalties for receiving kickbacks and charging unearned fees under RESPA include civil liability to the parties affected, equal to 3 times the amount of any charge paid for such settlement service. The possibility that the court costs and reasonable attorney's fees could be recovered, a fine of not more than $10,000, or imprisonment for not more than 1 year or both. Although RESPA prohibits kickbacks, unearned fees, fee splitting, etc., it allows for normal promotional and educational activity are fine as long as they are not conditioned on referral of business. Thanks for watching.